For judgment, item number 1 with item number 2.
The
Yes.
section 5 is allowed. GA.com 1 of 2025 is allowed, thereby continuing the delay. But the main matter is dismissed. Sorry. Accordingly, GA.com, not only sorry, double sorry, because accordingly, GA.com 2 of 2025 filed in connection with APCOM 824 of 2024 is dismissed on contest with costs of rupees 50,000 to be paid by the recall applicant to the respondent in the recall application within 30 days from date. Urgent certificate copies. 30 days because you get the time for filing.
Grateful, my lord.
Video upload. Upload হয়ে গেলে অ্যাপ্লিকেশনটা করে দেবো।
Item number 3, review application.
May it please your lordships. Item numbers 3 and 4 are being led by Mr. Vijay Purohit. He's appearing online.
Yes.
I'm appearing on behalf of the award holders.
Milaj, I seek leave to appear online, Milaj.
Yes.
Milaj, on the last occasion, I had submitted that the parties were in the midst of a settlement.
Right.
Now, the bankruptcy court has approved that settlement, Milaj.
Very
Yes, my lord. We've taken out a master summons, Milaj, and we are ready with the apostilled copy of the settlement
Right.
also, my lord. So, my lord, would your lordships take it on record or should we file it with the registry? Because there are certain steps that the parties are to take immediately, including that ICICI bank account.
So if you have a copy of that, I'll take on record and dispose of this matter.
Milaj,
And
that would
give you
be...
liberty to take appropriate steps wherever you want to.
Yes, Milaj. Milaj, along with the joint application, Milaj, we've
Yes.
also, for your lordship's kind consideration, we have given a draft order if your lordships could consider that.
All right.
Deem it appropriate, Milaj.
So where is that? I mean,
My colleagues will just hand it over, Milaj.
yes.
3 and 4.
All the parties are signatories to this, Mr. Purohit?
Yes, my lords.
Very good.
Except, of course, Mr. Damodaran, who was yes, ma'am.
Except
Mr. Damodaran, who was removed from the area of the parties.
Number 6, he was removed from the area of parties.
oh yes, he was removed.
Yes, ma'am.
Right. So where is the draft? This is the draft order.
We have the consent.
My lord, it's the consent order.
Yes.
That's annexed to the...
Why are there two? Three?
Lordship, it's
Same thing.
same thing.
One for the second judge and one for the little boy down the lane.
Item number 3 and 4, right? Both.
3 is review. So, fit a 4. Item 4. So,
3 and
3 is review. 4 is
Very well, Mr. Damodaran. I'll Mr. Purohit. I'm extremely sorry. Mr. Purohit. Just a slip of time. I'll pass an order, dispose of the matters in terms of these directions. And
Very
this
well.
will be made a part of the record so that you can proceed.
Grateful, my lord.
Lordship.
My lord may also keep in record our consent to the same. We have an email from the just
You
for
are
the record.
you are which entity? Apple.
My lord, I am for the responding numbers 1, 2, 3, 4, and 6.
Well, I am for appeal.
Learned counsel for the parties submit that the parties have arrived at a mutual settlement out of court. Full stop. Next para. The signed settlement, comma, containing the terms of the same, comma, is filed in court today and kept on record. Full stop. A printout of an email communication on behalf of the respondent numbers 1, 2, 3, 4, and 6 agreeing to such settlement is handed over in court today and also kept on record. Full stop. Next para. The parties hand over an agreed order in the format of certain directions contained in clauses A to H, capital A to capital H thereof. Full stop. Next para. In view of the settlement arrived at between the parties, comma, ECCOM 207 of 2024, along with the connected applications bearing GACOM, subquota GA number, are disposed of upon passing the directions as contained in the draft consent order, which is made a part of the record. Full stop. Let the draft consent order and the terms of settlement be deemed to be a part of the order. Full stop. No orders to costs. Thank you.
Grateful, Lordships.
Parties are given liberty to take steps in terms of the settlement at the earliest.
Grateful, Lordship.
We are grateful, my lords. And
The review is also ec.com আগে করে দেবে RVWO 4 of 2025 with GACOM 8 of 2024 as well as তারপর যাব ECCOM 207 of 2024 along with connected applications are disposed of.
grateful, my lords. And it has been an honor appearing, my lords.
No, not only it's an honor for that's mutual, but thank you very much for settling the matter because these things send the right messages probably to everybody.
Yes, my lord.
Thank you so much to all the parties and the council mostly. Thank you.
Grateful,
Grateful,
Lordship.
Thank you.
ঠিক আছে, ঠিক আছে, ঠিক আছে। Item number 5, Kolkata Metro Rail Corporation Limited.
Oh, you're ready? I thought it would taken up by surprise by this previous settlement.
That the side's not here, my lord. I can continue.
You can start because this
Yes,
is pending for
yes,
quite
yes,
some
yes,
time
yes.
and nobody is there. So they'll come in. But, Mr. Chaudhary, I'll have to rise today at 12 and not come back. I mean, so I give you an idea because I don't know how long you'll be continuing. So up to 12, this go. You can start, Mr. Chaudhary.
Yes,
They're not there, not difficult.
absolutely. Lord, I'll try to finish it by 12
Thank
so
you
that
very much.
it's completed.
Right.
And Monday I'll give the note.
So since this is your rejoinder reply, I mean,
Yes.
then I'll conclude our
Yes,
written
yes.
notes on.
We should also, my lord, try to conclude instead of
Thank you.
keeping
Then
it back.
but the judgment will be after the vacation then.
Naturally,
Dispose
my lord,
of
it will be.
দুটোই dispose.
But, my lord, once I, my lord, do this, then, my lord, at your lordship's
We'll
convenience,
get the time, yes. Thank you so much.
my lord, I'll ensure I conclude. Because there is also some commercial urgency because if I am to succeed, my lord, or if I am to fail, that will have have a bearing on 3 further arbitrations.
Yes.
So all arising out of this
the
contract.
ramifications will be larger than this.
1,000 crores.
And this is public money.
Public money, 1,000 crores.
Right.
Because right at the end, I'm going to show your lordship that there's a declaratory award which says that now all expenses which you keep incurring, I'll be liable to pay it, which is their source of sustenance in 3 further arbitral references, claiming 500 crores.
Those are pending before the regular bench.
No, those may not are in arbitration.
Oh, sorry, arbitration.
One of the 3 references I've concluded.
All right.
I've used the interim order
Right.
to say that it's not final. It's in the nature of an no. I'm not convinced with the argument myself. Setting aside is not a regular appeal. This is not open
No.
just because
Not a
30
continuation.
though I have argued, but I have said that I also have some doubt as to the correctness of the argument. However, that award hasn't come.
Don't be so fair.
No, you can't and technical arbitrators you can't mislead in law, and you can't mislead anybody in law.
That is the culture which should be there. I mean, that takes care of early disposals also.
And
Thank you. So let us start.
now, my lord, 2 paragraphs of the award, which
Audit.
I have never, my lord, because it's always at the end. I am never, my lord, to my satisfaction, placing them. My lord, paragraphs 122, 121 and 122. My lord, I want to read them first and then, my lord, give my reply. Last time, I think I couldn't read them. I missed them.
Ah.
My lord, this is right at the end.
Yes.
This is
121.
page 80, internal page 89, and lordship is looking at that volume, page 299.
No, I've got this. I've got the awards
Separately.
Yes.
So, my lord, it's internal page 89,
Yes. Got it.
para 121.
This was placed by you previously. I have my markings, but please place
Yes,
it
but
again.
sufficient time not spent. A lot of theories and opinions will keep on emerging as we go deeper and deeper into the micro issues of causes of failure, and would be a matter of several technical papers in the journals in the future. And after research, some of the conditions which lead to the accident may become clearer and clearer with the passing of each day. We are here to judge the issues from the engineering point of view. Engineering is not a pure science but an applied science with lot of design constants and coefficients derived based on past experience. Now this is a sentence which keeps recurring in the judgment whenever the arbitral tribunal feels that it is required to give reasons. It uses this sentence. It is possible that after the present incident also some of the coefficients and constants could stand modified, like the additional modifications carried out while carrying out the work after the incident. However, these are just preponderance of probabilities with improvements to cover any further unforeseeable physical condition. Engineering evolves constantly by having a healthy mix of theory and ground experience. And this is how empirical formula and future guidelines/codes get upgraded. These improvements have no end, and no one can be sure if these improvements could have contributed to the safe passage of TBM2 or were just superfluous additional safeguards. None of these theories can put a definite blame on the claimant's conduct on the date of the accident. Now I'll pause here, my lord. Why is the question I asked the award. And your lordships have said if it's with reasons, the why or the what should be answered by the award. Thus, unforeseeable physical conditions in terms of section 4.23 of GCC on the day of the incident appears to be plausible assessment to the entire incident. The case of the claimant is accordingly allowed. In the detailed hearing of both the sides and after studying the evidence presented before the AT, it is clear that there is nothing to firmly prove that the incident of 31st August 2019 took place due to acts of commission and omission on the part of the claimant, as also there is sufficient proof that it is more a case of unforeseeable physical situation, and the same has to be treated under clause 4.23 of the contract. At the same time, clause 4.1 and 4.2 of the contract have importance, and according to the two sets of clauses together that comes into play, claimants cannot be held responsible for the incident. They are exactly contrary to 4.1 and 4.2. Therefore, they cannot be made to ask to bear the losses that took place in the near vicinity of the incident, such as the cost for the shifting, rehabilitation, rebuilding of damages caused as per clause 4.23 of the contract agreement. But at the same time, please note this, the respondent cannot be held liable for the expenditure that the claimant contractor has to make to retrieve the plant, machinery and restart the work. And both the parties should cooperate and work jointly in order to claim the same from the insurance company as part of the car policy. That's not the insurance policy. Now, my lord, with this finding, wholly incorrect, but with this finding, what follows is that all claims for damages, loss suffered because of the incident, has to be recovered from insurance. But when the operative part of the award comes, dealing with the claims, wherever I have lost, all the claims made by the claimant, I have to bear. And where they have to bear, I have to go and claim it from the insurance company. I have made so that I don't have to go through 20 pages of claims, I've made a one-page chart. From the beginning, and this is, our omission, we should have recognized, the tribunal. Now, this is, a very stark fact. This is one fact which is, very, very hard-hitting. That very well, if insurance is to pay, that's your finding, then both will claim from insurance. Why one side? Number one. And when I say one side, I say mostly one side, 80 to 85% of the claims. Second is, their experts are good, proper, independent, and by the award, the cost incurred for obtaining that opinion, has been saddled on me. I've had to pay as damages, costs incurred for their experts. But when it comes to me, IIEST Shibpur and IIT Madras are partisan, biased, and their, my lord, findings, observations, data have been, my lord, disregarded. This shows the mind of the arbitral tribunal. Now, my lord, I'll quickly, my lord, on the last day, I'll not start from where I left off instead of trying to reach back. On the last day, my lord, I had started, I'll just indicate the paragraph numbers. I'm sorry, my lord, kindly give me. Yes. Yes. I had started from paragraph 97. If your lordship takes it once, I won't even try to read it. 97 has a list of the reports there. 98 has assessment of the 80 of the factual evidence from the study of these reports. And I had referred to subparagraph D to say that claimant had engaged independent agencies. So independent is, my lord, splashed all over, my lord, when it comes to their experts. And, my lord, I criticized subparagraph E.
Yes.
Because claimant's case is recorded and accepted for no good reason, according to us. Then, my lord, I'd gone to paragraph 99.
I'd ask you something, Mr. Chaudhary.
Yes.
Your reports and their reports were divided between pre and post incident.
Yes.
Both of your reports.
No, my reports
Yours were
are all post.
all post.
The ones which I rely upon are all post.
All right. And theirs are pre as well as
All pre. And this crucial fact is, my lord, noted, but not, my lord, dealt with as they should have been done. Now, my lord, to confuse matters, my lord, they say IIT Madras and Dr. John Endicott is pre and post. To clarify, when the incident happened, the division bench stopped the work. The, my lord, public interest litigation bench, my lord, stopped the work immediately. We had stopped it. And that was, my lord, put down in the order of the division bench and no further work. We will now monitor. We were asked to take steps. That's when, my lord, we created a high power committee headed by Dr. John Endicott, who's, my lord, one of the topmost tunneling experts in the world. I had the privilege of, my lord, interacting with him. 87 years old. He runs inside the tunnel. A PhD from Cambridge. He's the one who's made NEOM, that city in, my lord, Saudi Arabia, which has, my lord, levels of tunnels.
he's
the man who's made NEOM. And he was explaining, my lord, what was in his mind when he did it. The difference, my lord, between him and all the other experts. And I told my juniors that, see, this applies to us also. We must learn. When all other engineers explain, my lord, of foreign science to you, you stare at them. spend half an hour not going in. When Dr. Endicott explains, in 3 minutes you understand. So, my lord, Dr. Endicott and 3 other persons, Guy Bridges, Dr. Pichumani from IIT Madras, they were brought in. They studied and gave a movement forward plan to the High Court. High Court said, have it vetted. Then it was sent to IIT Madras. IIT Madras vetted it and said, this is the way you should move forward. In those reports, both Dr. Endicott and Millard Hyper Committee both say that A, B, C, D could be the reason. It could be aquifer, it could be artesian condition of water, it could be bad handling of TBM. Till retrieval, we can't say with certainty. But the measure which we now follow is do it this way, and I'm going to indicate who's going to steer the TBM. And it was done. Now, these are pre-retrieval also. So are their reports. What is their post-retrieval? IIT Shibpur with soil, IIT Madras considering soil and giving the way forward, and my evidence by Millard, the consultant, Dr. Ken Wong. These are the only 3 reports. So this is the way it stands. Now, Millard, let's Millard immediately proceed forward. Also, Millard, when your lordship sees their reports, 3 factors are very important. Number 1, the reports rely on A, hearsay, B, newspaper published 50 years ago, C, articles published 75, 80 years ago. Hearsay as in they say I've gone and spoken to people who were there at site. And it's not a conclusive report because they're all pre-retrieval. So this, Millard, is there in the note, and I've also indicated before. Now, when we come to, Millard, I'll now come straight away to just to give your lordship an example, paragraph 107 is the IIT Madras review of expert committee. Paragraph 107, internal page 69.
Yes.
IIT Madras review of expert committee report on proposal to resume tunneling. This is that earlier report. I'm not on this. Millard, I am on paragraph 109. In fact, I'm sorry, Millard, paragraph 108. And I want to read one sentence from their notes. Para 15, and this has been their argument also. The tribunal, on the basis of a detailed analysis of the facts, circumstances, events, and conduct of the parties, reached the conclusion that reliance could not be placed on the post-retrieval reports put forth by the petitioner. This is their case. And one plausible view reached. My effort is to show, I agree with, I humbly agree with my senior learned friend, Mr. Shah, that if one plausible view, if there are 2 plausible views, one will remain. But I say, my lord, there is no plausible view which has been shown by them, and therefore it is extreme perversity and unfairness. Now, my lord, I'll quickly take your lordship through, my lord, the consideration, because this is the fulcrum of the matter. Page 108. I'm sorry, para 108.
Yes.
This is IIT Shibpur. Soil dynamics with the soil post-retrieval, which, my lord, engineers call disturbed soil samples. And there is only paragraph G is the only paragraph dealing with the contents of the report, which is not in fact contents of the report, which is independent, not independent. So, my lord, I not going to look at it. However, as per written notes of argument, respondent has made a statement against counterclaim number 4 on page 105 that the respondent for the purposes my notes of argument. And then the report is one such listed report as per the statement of the respondent. Thus, this is not an independent report and prepared subsequent to commencement of the case for the sole purpose of defending the case. This raises the doubts about the intent and evidentiary value. That's it. Now, my lord, I want your lordship to, for 1 minute, my lord, take up volume 44. I'm sorry, my lord.
IIT Madras was also yours.
Yes.
That has been discussed at length.
Next paragraph. No, not at length, my lord.
Achha.
That's going to be my endeavor.
We will come to that. Volume
My lord,
44.
here, my lord, I want your lordships to.
Yes.
I'm sorry, my lord, volume 43 also. 43. My mistake, my lord, I should have.
Yes.
Just, my lord.
Voluminous mistake.
Yes.
Which page, Mr. Chaudhary?
Yes, I want to, my lord, show your lordship, page 71. No.
Not this.
No. It's later, my lord, I'm sorry. My lord, 7141.
Yes. This is IT sheet put.
Signed by, my lord, Professor Ambarish Ghosh.
Yes.
To digress for a minute, I like the way, my lord, he signs his name. Lordship will see he doesn't use, my lord, doctor.
No, but people who are doctors, they in the signatures they put doctor.
A lot of people do.
Signature.
A lot of people do.
Is there magnanimity that they do it? Or megalomanianity?
Yes.
Doctor in signature? Anyway.
Well, even famous, my lord, medical practitioners abroad, my lord, they will sign Mr. They will write Mr.
Should I sign Justice Soposaji? What is this?
To digress, I have,
demit office the day I do it.
I have seen it happen.
Justice? Signature? No. You're joking. You show it to me someday.
My lord,
So that I can.
we are all getting older. My lord, one day, my lord, maybe within, I don't follow, after 10 years or something, when I see your lordship.
You are getting older means after my attaining 62 years. So we'll have to, that is too long. We'll have to meet some other day.
I am now.
Some formal program so that there is no aspersion
Yes.
cast. Everybody will be there, some bar
No,
program.
I run away. I don't.
There's a photo unveiling on someday, 26th. It says S.B. Mukherjee.
Yes.
So that will be a good day.
That
In
will
front
be
of public, just whisper to me the name. Anyway.
Minute 7. All I want your lordship to see is 7144. Background noted. 7145. Third paragraph. Expert team of IIST Shibpur has carried out experiments on the samples given, prepared the soil stratification based on pre-post incident borings, and studied the following documents for preparation. Report on soil investigation, additional soil investigation, etc. Design documents. What they do is what they call a GIR. They prepare it on the basis of borehole logs. They do boreholes at a certain spacing, and with the results, they do their tests, prepare a GIR, geotechnical investigative report, and that's a complete soil report. On that basis, the DPR is prepared, and then the contract is floated.
So to get a profile of the underground terrain.
Yes.
Sort of.
So, two were done before we started. One was done by them when they gave this is a realigned portion done by them. So that is considered, disturbed is considered, and then the Next page, my lord, 7146, study location. Then, my lord, 3.1 at 7146, summary of field borehole logs. Then, my lord, this goes on, summary.
So you see that all of this was discarded with a single sentence.
Single sentence.
It's,
Single sentence. Then, my lord, idealized soil profile, 3.2. Then 3.3, my lord, which is the last page of the second last page of this volume. Index properties of soil from laboratory test results. Then, my lord, last page, grain size distribution, Atterberg's limits. Then we go to the next volume. And
don't try to flabbergast the court with the technicalities. So
no,
that
Miller, we
are impressed that this is a good report. We know nothing. It may be a good report, maybe a bad
we know
report. But it's detailed. It takes into consideration so many things.
That is what
I can understand as a layman.
And it goes on. No, I want your lordship to also see, my lord.
Should have been adverted to. That is your. I mean,
yes,
at least.
There's so much.
And these people are engineers because they proceed on the premise that engineering is a whatever science and
applied
imperfect science.
Yes.
Now, applied, but it's developing.
Developing.
That's true.
And my lord, 7161 law is also a developing subject.
Law is more of an arts than it's more in humanities.
No, as a subject, it's an evolving subject.
But engineering, everything is evolving.
Everything is evolving. So, my lord, there is no gain.
No, we have more scope of evolution because it's a subjective thing sometimes. Yes. So we feel it to be objective because we set the standards and we say that standard is objective.
No, it is.
But engineering is more of an applied science.
It is an applied science and based on, my lord, newer, fresher.
Empirical in a sense.
Empirical, but based on fresher thought, the conclusions change. For us also, my lord, the same thing happens.
Everything. The entire worldview is changing in science. So no difficulty, yes.
My lord, conclusions are at 7161.
7161, yes.
Up to then, my lord, detailed consideration.
Yes, I've seen that.
I want your lordship to just see one page, 7156. Lord, there's
those
a
dots,
box, my lord, which they put in these dots.
Yes, I've seen that.
What was, and below that, my lord, table 7, summary of grain size distribution. Lord, what is important here is that a theory, Lord, we have been able to show, or we've tried to show through these reports, that the nature of the soil was such that there is no real possibility of there being a huge water table, which is what, my lord, they are saying must have happened. They are not, my lord, saying that it has happened. They are saying it must have happened. So I have to bring, my lord, evidence to show it could not be there. Now, how do I, my lord, say that? I say that by looking at, my lord, the soil conditions. The theory, what was explained is what we also argued in the arbitration, not noted, not recorded, but discarded, is for there, my lord, to be an aquiferous condition, there must be, my lord, a water table, and the soil condition must effectively, my lord, trap the water in it in such a way that water pressure would cause it to, my lord, flow downward or upward, which can potentially create a situation where there is this sort of a situation. Now, soil conditions do not show that, and that is what IIT Shibpur says.
This was at the location of the site of the incident.
Yes. At
Obviously,
the exact site of the incident, because disturbed soil samples taken. So, detailed report. Now, my lord, one paragraph gone. Then, paragraph 109. This, my lord, will give your lordship an even greater picture of, my lord, the one-sided determination rejecting everything. 7086 at volume 43 is, my lord, the fate of 7086 is decided in paragraph 109.
Yes.
And this is IIT Madras.
Right.
Based on whose determination, my lord, tunneling recommenced by that earlier report. That was vetted by IIT Madras. Dr. Endicott committee report vetted by IIT Madras, taken on record, by, my lord, the High Court, and then, my lord, we were allowed to recommence. And after, my lord, everything, my lord, this report comes to show, my lord, that all this is not correct. Now, I'm going to show your lordship, there is one sentence here to discard on merits, one sentence on merit to discard a 100-page report. But that one sentence is so flawed and so, my lord, packed with predetermination that, my lord, that shows, my lord, the mind of the arbitral tribunal. My lord, may I take your lordship to paragraph B? Statement of claims was submitted by claimant on 3rd November 21 and report was submitted by IIT Madras on 17th February 22. On perusal of the introduction, it appears that this is not an independent report. Same reason. Consultants of IIT Madras studied geological condition. TBM was done by Dr. Page. Combination of two reports. Dr. Page was brought in by IIT Madras as a tunneling expert to, my lord, buttress their views. Now, my lord, paragraph D, again, not independent because it's for the sole purpose of defending the case. Now, my lord, in a case like this, if I can't bring expert evidence, then what do I bring? Nothing. This is contrary to the fundamental principles of our law. Now, subparagraph E. Now, this is the important paragraph. Moreover, IIT Madras in the introduction has stated that the report has been prepared based on the data supplied and all the photographs from the daily progress report of TBM retrieval. It is important to note that as per the scope of work, VD letter 25th February of KMRCL, the scope included inspection of affected TBM to study contribution of the component of the machine. Importantly, this is the important sentence. Even though IIT has relied on the photographs of the retrieved TBM in para 4.29 on page 1014 of SOD, the author specifically mentions that the quality of the photographic evidence cannot guarantee the accuracy of the comments made by Dr. Lee Blade's report, GC's representative. Hence, the conclusion with regard to TBM brushes is not considered dependable. Only one sentence. Now, what has happened here? Dr. Lee Blade is, my lord, our person, GC's representative. GC is engaged by us. When the TBM is retrieved, my lord, it's cut into sections to study, my lord, what is the situation, and photographs are taken. Dr. Lee Blade's report, now, which volume?
Yes, I saw the photograph somewhere. In
Yes,
either of these
my lord,
two.
I'm going to show your lordship Dr. Lee Blade's report. This is page 6968 at volume 42.
No, these are the same photographs, page 70987.
Yes, taken out from there. But
out
I'm going to show your lordship what Dr. Lee Blade does. It's called the tailskin brush seal recovery report. Now, please see 6968.
Yes, yes.
Kolkata East-West Metro tailskin brush seal recovery report. Now, it's, my lord, page 6971. Lordship will find removed sections referred to. My lord, he cuts it into portions and he takes pictures and he gives a finding to the GC. Now, my lord, please come to yes, my lord, for each section, my lord, let's, my lord, take 6983. My lord, please take 6983.
83.
Yes. And I'll give you a lordship, my lord, what is the report. So this is there for all the sections. This is the first removed section. And what does it say? The first section located at jack position 16 was removed and inspected on the surface on 25th November 21 at the same time as ITT JV and Herenschnitt. There was no grease observed. Although there is a spare grease injection port at such and such, furthest point between grease injection ports.
So did they physically see the
Yes, yes.
sections?
Yes.
Not reliant on only the photograph.
No, no, no. No, no. IIT Madras. IIT
This-
Madras did not. This gentleman
This
did.
gentleman, yes.
Yes, he did.
His IIT address depended on this,
He depended on this.
but he saw those.
He
first.
saw he's not his pictures of the sections.
Oh.
So he says first row inner 90% of brushes have been lost. The remaining brush is 90% worn. There is no grease seen and first chamber full of grout. Second row 95% lost. Third row 100% lost. And in this, and then he gives the photographs because he's the one who's taken it out and cut it and he submits it to GC. Now, please see Millard 6988. Same thing. First row inner 100%, second row 90%, third row outer two number of 60%. So, my lord, he's inspected, he's seen, he's taken photographs, and he's given the percentage of brushes lost. Now, IIT Madras has this.
Who is the author of this?
This is, my lord, Dr. Lee Blade. Engaged by GC at the time of retrieval.
After 900.
Now,
And IIT Madras report relied on this.
relies on this. But, my lord, and that now I'll show your lordship IIT Madras report from page 7086. Now, my lord, I'll do two things together. I'll show what the report is by showing some, my lord, headings. My lord, oh,
This is 70.
my lord, please see, this is 7086 in volume 43. My lord, introduction is 7087. Then terms of reference. Then, my lord, 7089 to 7092 is soil. Out of which, my lord, and then let me not take time. Page 7092. After looking at all the data, studying it, second last paragraph
Yes.
at 7092. Hence, last sentence, hence, internal erosion of soil under normal operating conditions could not have taken place. Judgment is totally contrary to this. Then, I'm sorry, award is contrary to this. Then, from the observed soil conditions at the site before and after the incident, it is clear that the reasons for water ingress on 31st August 2019 will be other than soil conditions. The earth pressure balancing EPB type TBMs used in KMRCL project are ideally suited for the soil conditions prevailing at the site. The reasons for water ingress incident are most likely due to TBM related operations or leak through the gaps between the lining elements. So not the soil argument of the other side is rejected by data 5 pages. Then not considered. Then, my lord, 7093 to 7097 is investigation of TBM related aspects. The heading is at 7093. TBM related aspect is, my lord, what they do is, my lord, they study the rings. My lord, the tunnel is made of rings. Because as TBM goes forward, it ejects a ring. That ring, my lord, rings make up the tunnel. So when you look at the alignment of the ring, you understand whether the TBM has been moving properly or not. That is the consideration from 7093 to 7097. And the finding is at 7097 of taper, excessive taper. Then, my lord, 7098 is, my lord, tail seal. Those brushes. So, my lord, why brushes are there is 7098. Then, my lord, the purpose of the tail seal brushes, grease goes on. Then, my lord, 7100 tail seal repairs. Then, my lord, same, my lord, photographs. Then 7103 tail seal grease requirement discussed, because too much of grease going out shows that they were lost, they didn't remain in the brushes. Then, my lord, grouting is discussed at 7104. This goes on, and, my lord, the TBM data on grout, grease, etc. Then 7108 tunnel alignment, TBM articulation. Same, my lord.
Read the entire things.
Yes, no, important, my lord, is all of this is considered.
Yes.
Then, my lord, this goes on.
Yes.
And 7118 is removal of TBM1. My lord, I'm coming back to that sentence picked up, my lord, from the IIT Madras report.
Yes.
7118, removal of TBM1. The following comments are based on the removal of tail skin brush seal report revision 6 prepared by Lee Blade on 12 December 21. Please note, quality of photographic evidence cannot guarantee the accuracy of the following comments made in Lee Blade's report. Then, my lord, the photographs are given up to 7120. This is for one section. Then 7121. Again, the same sentences, my lord.
But Mr. Lee Blade personally saw those also. So probably what they meant to say is that
Percentage of brushes, he can't verify.
that one, and secondly, probably that IIT Madras cannot guarantee the accuracy of Lee Blade's
Lee
report.
Blade's report.
It's not that Lee Blade could not guarantee the accuracy. Lee
IIT
Blade gave his report after seeing it and taking photographs, and IIT Madras, when they see it, probably that accuracy is not. They are not sure of the accuracy because of the quality of photograph. Because they see the photographs only.
Yes.
But Lee Blade took the photographs and saw the segments also.
Yes. And, my lord, your lordship will look at 7121. My lord, these percentages which have been quoted, IIT does not guarantee. Whether 100% lost or 80% lost, IIT doesn't guarantee the percentage. But IIT's conclusion at page 7130. Now, please see 7130. Same photographs. IIT concludes from the last, my lord, bullet point at 7130.
Yes.
From the photographic evidence, the tail seal was extensively damaged. My lord, from a photograph, I can't, my lord, guarantee the percentage, but I can see it's extensively damaged. That's number one. Now, number two is, my lord, after this, this brush, the conclusion is at 7129, and very clear, my lord, that they are responsible. And same as 7130 is 7131, last paragraph of the report.
Yes.
From the photographic evidence at the time of skin removal, it can be seen that a large percentage of the spring plates and tail seal brushes are damaged or missing. There is lack of grease within the brushes and chambers, and much of the brushes and chambers are contaminated with grout. This would have led to ingress of water and fine soil particles into TBM tunnel.
And Mr. Shah took a point that the tail brushes were being changed at regular interval and regular places, and you were also complicit with that because you also knew about that, and it had stopped for the specific purpose of changing the tail brushes.
Yes.
So why should liability be fixed on them for this? I mean, they were doing the changes of the alterations of the tail brushes. Do you mean to say that the movement, the movement of the TBM was somewhat?
Yes, my lord, two things. To break down, my lord, the whole argument into 2 points is, number one,
Yes.
if you don't steer the TBM correctly,
So the operation itself was faulty.
yes, so what happens is you go close to the wall
Yes.
by maybe 1 millimeter.
That would also be corroborated by the frequency of the tail brush changes.
Yes,
But is there any proof on that? What should be the
zero. There is on record is zero, because when Willard it did it again, there was no tail seal brush change. No, I'll just clarify this. I don't want to make some.
cannot be zero?
Only four were changed. 4 brushes
But
were
there is no
changed.
clear evidence on that.
Yes, yes. Everything is there. And third, there is correspondence, which I remember having placed. There is a letter of GC saying that enormous grease loss is happening. There is ingress in the beginning of August. Please do something and change, because there's no other option to change. What option does not GC or the employer have? We can only tell you that we can only tell you that there is enormous ingress. You have to change. Then, my lord, it was compelled to stop. And half an hour after it stopped, my lord, this happened. And on the now to come back to the award, on the comment, my lord, just one more. The very fact that so many brushes were required itself is an indication that it was not being handled properly. And that was a specific argument made before the arbitral tribunal. Notes থেকে বার করো না, বলেছিলাম এটা। The evidence of improper steering is, my lord, the angles of the rings and segments, which has been studied in detail by IIT
You
Madras.
say that if there is too much to excess of grease overflowing, I mean that
Yes.
means the tail brushes are not in proper place. Or
Exactly.
not there.
Exactly. You know, simple example.
Because it goes out then. They're
Yes.
not absorbed by the tail.
Millard, you put, Millard, something which is less cohesive than toothpaste on a toothbrush. If the bristles are not there, it will go out.
Yes.
So evidence, Millard, and this was argued in great detail in arbitration, evidence is that the TBM machine itself shows how much of, Millard, number of strokes per of the pump, of the grease pump, number of strokes. And we have from the manufacturer's manual how much of grease by volume is sent by each pump. So we say that
There's
this
a
is
method
the
of
grease.
calculation. There is a method
Method
of
of calculation. Their answer to that in arbitration was that I have dipped a stick into the tank and I have found that it was much less. That was the answer, not discussed. And this, as your lordship will not observe, if it is excessive, then that shows that brushes had been lost. Number of stops and changes shows that brushes have been lost. Why have brushes been lost? because maneuvering is not correct. You're going too close to the wall. And detailed evidence, my lord, is there before, in the form of reports before the court and before the learned arbitral tribunal. Now,
Yes.
my lord, to come back to, my lord, the award, 283, subparagraph E.
Hmm.
Last paragraph. Hence, the conclusion with respect to TBM brushes is not considered dependable. So, whole, my lord, consideration of IIT Madras report, all that data, my lord, goes with this one sentence. My lord, the learned arbitral tribunal picks out one line. Then, my lord, next paragraph F. Also in the discussion and conclusions at 4.210, last para, the report states that from the photographic evidence, same sentence. Also, this conclusion is contradictory to the basis of observations about poor quality. So the only thing he sees is that one sentence, poor quality, which comes thrice. And that's the end of the entire consideration. To summarize IIT's report, soil, and a conclusion that the other side's argument on possible cause is rejected. Soil conditions do not support. First part. Second part, TBM movement, rings, taper, etc. Then tail seal, brush, my lord, findings. All of it goes on this one sentence, this and bias. Then, my lord, page 284 is my evidence. GC's report.
Please refer to the internal pages.
I'm sorry, my lord. 74.
Yes.
Next paragraph, para 110, page 74.
Yes.
Evidence of GC. This is the most voluminous, has to be, my evidence has to be there. Project director Ken Wong, my lord, submitted this report. He was the one who wanted to lead evidence. I am just going to show your lordship, my lord, the GC report. Kindly give me, yes, my lord, page 280. Oh, yes, 66798, volume 41. I think, my lord, volume 41 from page 6798 up to, my lord, IIT Madras's report is the GC's report. 3 volumes. Lord, this is extremely detailed.
Six, seven, eight,
6798.
9. It starts from there.
Yes. In fact, my lord, the statement of defense, my lord, and this were both prepared, my lord, preparation started together. So statement of defense is based on this. The earlier version of this, not the signed version. My evidence. My lord, the report, whatever, my lord, I have submitted, your lordship will find is really from the report. The report goes, this is my evidence. My lord, and it goes on.
Ken Wong was the GC.
Yes, he's the head of the GC, the project director. He's there. He's been there throughout. And 3-volume report. All possible data.
How was this dealt with?
My lord, please come to page 284. I'm sorry, my lord, page 74.
Yes.
I'll just read out, my lord. The background of the report at para A states that KMRCL formed expert committee by such and such. Further state the expert committee with such and such in connection with the root causes. Together with the project director, our expert committee together with Mr. Wong submitted preliminary fact-finding report. Report also says more than 15 things were done. Then GC in his report has stated 1, 2, 3. Now, my lord, kindly come to 5.
Yes.
My lord, there is nothing, my lord, before that.
No.
While GC accepted that the risk of inundation through tailskin is always a risk in TBM tunneling, he has not been able to give any records of having pointed out any unwarranted activity of the claimant during the currency. GC, being an expert in the field with a conglomerate of the best brains in the world, has not produced even a single evidence where GC could foresee the incident based on the happening at the ground and raise an alert to the claimant. On one occasion, GC has gone to the extent of stating that GC was not aware when brushes were replaced. Since he was present at site, such an argument is difficult to be accepted and he is shirking away entire responsibility. Then GC has stated that there are no records about the internal initial flow, no conditioned witness statement. This is either lack of monitoring or a deliberate attempt to hide the actual facts and raises doubt on GC's report. It is stated that report was submitted by GC on 22nd February after a gap of 900 days when statement of claim had been submitted, even though claimant disclosed all post-incident expert views to the GC immediately after submission of report. GC did not react. So there, my lord, reports had been handed over to GC just after the incident. GC did not react. First report, that's also wrong. That's also wrong. The first report, as is evident, was the purpose of submission to High Court, etc., etc. Then paragraph 9, contract clauses, my lord, referred to. Then paragraph 11, ET has no doubt to doubt the capabilities of GC. We don't blame the GC. Applied science. Then KMRCL has employed technically qualified and experienced contractor to execute the project and best brains in the world to monitor this on their behalf, in whose with whose directions claimant were acting. No indication that there has been any misconduct by anyone or claimant refused to obey the directions of GC. Misjudgment, if at all, happened. Entire set comprising of expert contractor, expert GC and KMRCL, not claimant alone. So this can only be defined as unforeseeable. It is thus apparent that report of GC was prepared solely for the purpose of only defending stand of respondent to avoid creating a liability on KMRCL. This is evident from counterclaim. This is the now, Lord, we come to, Lord, we've shown your lordship the clauses and we've highlighted it in the notes also. Contract says, GC, if there is any breach, it's claimant's responsibility. The breach and all effects of the breach are claimant's responsibility. GC will not be responsible.
Clause 4.1, 4.2.
Yes, my lord. 3.4.
3.2.
That nothing, my lord, it's set out, my lord, at paragraph 112, next paragraph.
Yes.
Respondent argued that no act or omission by the engineer or the assistants to the engineer in the performance of any of the engineer's duty or exercise of any of engineer's powers under the contract shall in any way operate to relieve the contractor of any duty, responsibility, obligation or liabilities. Then 4.1 is contractor shall take full responsibility. So, my lord, if we, my lord, go to these clauses, in a situation like this, it's your method. It's not your method statement. It's your technology which has been, my lord, accepted, and you are proceeding forward. If, my lord, there is a mistake and there is, my lord, an incident, in that case, you are responsible. That's the contract. Otherwise, my lord, in every case, my lord, please, my lord, if your lordship just twists the argument and considers it from the other angle, in no case will, my lord, in no case like this will the contractor be responsible, if this is the interpretation given to the clause. On the other hand, and this is what we had submitted, if today a contractor comes and says that, see, GC told me you do this. I told the GC if I do this, it will be a problem. GC insisted that I do this. And I did it, and that has resulted in this incident. You may be absolved of liability. But let's look at a situation like the present, where I am doing the tunneling. GC is seeing that brushes are getting changed regularly. GC is also cautioning me and telling me that you change brushes. This is getting too much. So much of water is coming in. And then the incident happened. And you say that because KMRCL engineers did not foresee it, because GC did not foresee it, all of you are together responsible. It's perverse. And especially in the face of detailed evidence given by us in the form of various reports, which, if summarized into 3 bullet points, is A, your maneuvering was not correct, shown from the angles of the rings. B, there was brush loss, which is a direct result of maneuvering mistake. And that is further proved by the fact that there was loss of grease. And C, the soil conditions are such that what you say, that TBM ran into an impossible large table of water, that is not correct. Relying on soil dynamics, not considered. Milord, I understand, Milord, but the fundamental issue is this entire body of evidence, 3 volumes of evidence, discarded by this. Next, Milord, paragraph 111 at page 77. চিঠিটা অগাস্টের চিঠিটা বার করো, অগাস্টের চিঠিটা বার করে দিন, জিসি চিঠিটা। Now, my lord, next is assessment of GC's role, paragraph 111, and my lord, it goes up to page 83. And my lord, GC, why did GC allow the work to go on? So therefore, I am not in fault. The fact that I have done faulty work is not my fault. You allowed me to do the faulty work. You did not realize that I was doing faulty work. So I am absolved of all, my lord, losses. And this is in the face of clear clauses of the contract that if there is any breach, claimant will not be, my lord, absolved. And then, my lord, without considering anything, my lord, is the finding at page 85, subparagraph B. there is no contrary evidence. My lord, this is the limit, if I may say so. My lord, there is no contrary evidence to the statement of the claimant that sink of TBM is not due to the fault of brush. The brushes available with TBM at the time of incident were enough and capable to stop the ingress of water. From the various soil reports, it can be concluded that highly dispersive nature of ground contributed strongly to the extraordinary and with the then available means uncontrollable ground loss below TBM, and due this the other issues were evolving which are not possible to be envisaged. So my lord, first finding is sink of TBM is not due to fault of brush. To come to this finding, you have to reject all my evidence first with reasons. That's why we go to, my lord, an arbitral tribunal with experts. Next, number two, it was not possible to be envisaged at the time of commencement of tunneling work. I'm sorry, my lord, the sentence before that. Page 85, last sentence. From various soil reports, it can be concluded that the highly dispersive nature of the ground. To come to this, you have to reject my reports on soil, which say exactly to the opposite. This large data has to be rejected. The findings of IIT Shibpur have to be rejected. The findings of IIT Madras have to be rejected. Where is the consideration? I ask myself the question. At the point, next page at the top, at the point where the tunnel was damaged as the TBM sank in, more gaps opened for the water to enter the shield and disperse more ground. No consideration of anything. And Lord, he keeps on repeating. Lord, please see the earlier page once, my Lord. Page 85, paragraph AF. IITM's final report cannot be an impartial, independent assessment. Then, my Lord, AG. IITM reports rely upon SPT values to state that higher SPT values indicate that the soil is reasonably strong. However, now, my Lord, it's rejected. However, since all the three arbitrators are engineers with more than 40 years of experience, and one of them being a postgraduate in geotechnical engineering from IIT Delhi, the professional knowledge makes them differ with the report, as SPT values can be misleading. And in case of saturated silty soils, even when the soil is weak, SPT values can be high. On what basis? I am qualified, I know, cannot be the basis for a conclusion. This is a judicial proceeding. Then a judgment would be suffice to say that I conclude that this is this. And I know, because I am a lawyer with 30 years standing or a learned judge, so therefore I conclude that this is that kind of reasoning. Now, my lord, this, and after this, my lord, paragraph 121. Lot of theories and opinions, my lord, which I read out. Now, my lord, just one document, and I have around 12 minutes, my lord, to finish. The three, this is, my lord, volume 3.
ঠিক আছে এগুলো নিলাম
363. This is Milord volume 3, macro 363. This is GC, Milord, writing to my learned friends, clients. Dear sir, and Milord, please note the date, Milord, 28th of August, 3 days before the incident. Dear sir, as you are aware, there is now an increasing concern for the condition of the tail seal on both EPB TBMs advancing towards Shialda station. The tail seal is critical for this type of tunneling and plays a major role in elevating surface settlements and attaining successful grouting. TBM status at present is as follows. At ring 1202 of such and such, mining through soft water charge, silty clays and fine sand, tail seal condition is extremely poor with only 20% of brush. Two soil inflow incidents recorded in the last 7 days. At ring 957, Milord, showing sign of failure with grout inflow. Joint site discussion has taken place, and it is agreed that TBM1 requires a full 2-row tail brush repair urgently. Based on indications, TBM2 will also require a 2-row tail brush repair before the expected soil changes. Unfortunately, due to number of factors, tail seal brush repair is not possible at present because you have no stock of replacement brushes. Additionally, the soil conditions for TBM1 and its present urban location means that a long repair stoppage is not ideal at this moment. In respect of the above, GC recommends that you manage the tail seal zone as best as possible until repair can take place. There are various techniques to achieve this, including the following. Maximize grease pumping, packing ring, packing inflow zone, target grouting, use of thicker denser, full ring grouting,
This
operating.
also shows, Mr. Chaudhary, that despite knowing that these were in very bad condition, the tail seal,
Can't be stopped, Milord.
you
Milord,
said it
please
could not
see
be stopped,
this.
and we manage it.
Yes,
And
you have to
maximize-
manage it.
Maximize grease pumping was also one of your
Yes,
advice,
because you're losing grease.
which could have led to this excessive grease being there.
No, this is, Milord, 3 days before the incident. Milord, you're losing grease. Milord, if you're losing blood, you put more than required blood. So you're losing grease. So pump in more. So at least something will remain. And why? Milord, please see this. Unfortunate second paragraph at page 363.
Yes, Sri.
Unfortunately, due to number of factors, tail brush repairs are not possible at present because you have no stock of replacement
You
brushes.
never say that your maneuvering is defective or something
We
like that.
can't know then. We can't know.
As
We
a possible reason, you give so many possible reasons, not possible reasons.
no, not reasons. This is what you can do to manage. This is first aid.
Hmm.
And Milord, when can I know that maneuvering is going to be possible? It's only after retrieval.
Hmm.
And what am I saying? I am, Milord, saying A, you don't have brushes. 2, soil conditions for TBM1 and its present urban location means that a long repair stoppage is not ideal at this moment. So manage.
Hmm.
And Milord, kindly see 364 after Milord first aid. In respect of TBM1, you should now plan the best stoppage location for an estimated 5 to 7 days to complete full 2-row repair brush replacement and introduce factors to reduce settlement during the work. Longer term, you should make preparations content. I am an advisor that 800 meters of westbound and 1,100 meters of eastbound tunnel still to excavate and build before Shialda. Based on the fact that you're down to only 2 rows, the performance of the tail seal so far and the previous repairs already complete, is safe to assume that there will be more stoppages and tail seal brush repairs required before Shialda. A plan should be produced for identification of urgent repair stoppage location, next repair stoppage location, future best stoppage location.
This was your evidence in the proceeding.
Yes. And Milord, not only one. Now, Milord, see 371. At Millard,
Yes.
372. This is ITD's letter. The tail brush replacement was to start from 1st September 19. The replacement brushes reached site on 30th August 19. And below that, Millard, first time brush change for 7 days in May, second time brush change in July. Now, the finding of the arbitral tribunal is that they had the brushes with them. And we said you did not have, because our letter clearly says you did. The second letter that it's coming on the 30th, this is much after the incident. Now what they do is, last day of arbitration hearing, last day, page 11320 in volume 71 is produced. Last day, at conclusion,
One one three.
111320. And given to us with the notes. It's we have annexed the notes also. The typewritten page suggesting that 147 brushes were needed, out of which 100 brushes allegedly came on 30th August 2019, which we say is wrong. It wasn't there on 30th. On the other hand, other documents before the arbitral tribunal will show that they were dispatched, from Chennai on 30th August. That's 11347. From their documents we argued. How are you saying that you had 100 brushes reaching? When we made this argument, they produced this on the last day. And and then pushed it in with the note. Handed up something in court last day, just before closing, annex it to the note. And arbitral tribunal proceeds. Please 311347. Herenschnett sends them the brushes. Received, who's the TBM manufacturer, wire brush seal, 100 quantity. Lordship has seen 11347. And see the ITD, please see the receipt date. Esplanade, 2nd September. Third. They didn't even have the brushes.
The date of the incident was
31st August. And time of dispatch. My learned friend says it's there, I must have missed it. Invoice date is 30th August. No, this is time of receipt is there. This is the 3rd September.
both parties sign on third.
No, I'm sorry,
Both parties sign on third. That's why there are
yes,
two signatures.
Yes.
Receipt date was third.
Yes. And awarded জায়গাটা চিট বার করো আর awarded জায়গাটা দেখাও যেখানে বলেছে ব্রাশেস ছিল. And there's another letter also. my lord, at page 85 of the award, which I read out, my lord, there is no contrary evidence to the statement of the claimant that sink of TBM is not due to fault of brush. Brushes were available with TBM at the time of incident. And also, my lord, please see, my lord, 6795. This is, my lord, record both of us had. My lord, 6795. This is post, my lord, incident letter given by us, volume 41.
Yes.
When we were, my lord, exchanging letters, and we were telling them that you knew what to have known, etc. Please, my lord, see the last page. I want to show your lordship that. Please see the table below, which records incidents of 13 days with inflow of material from 1st to 28th August 2019, as recorded by GC staff during inspections for tea. Records would show water, grout, and soil was getting past 3 rows of brushes. Then, Lord, please see the next page, 6796.
Yes.
This table is, my lord, records available with both throughout, my lord. Minor, minor to heavy, then it stops. Then, my lord, please see from 20th August, it increases.
Yes.
Minor to heavy, minor, moderate to heavy, minor, 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 and then 31st August, heavy and continuous.
What was this? Heavy and continuous what?
My lord, this is inflow.
Inflow.
So, my lord,
Yes.
I'll just take 1 minute, my lord.
Yes.
Number one, you are responsible for your work. We are advisors. I haven't given you any instruction based on which this has happened. This is what you had done. Number two, you didn't have brushes. Number three, we did not know that you were not able to handle it. Even experts did not know. It is only after retrieval that it was possible to know that the reason for the brush loss was possible to be known looking at the taper and the angles, etc., which is what all the
The
experts have said.
post-retrieval reports are not looked into.
Not looked in. So I couldn't have known, my lord, this GC argument, my lord, is peripherally attractive. But if your lordship sees beyond it, my lord, it's like a contract supervisor. My supervisor at site is there. But is he responsible? He's an advisor to you. And now,
Supervisory and advisory capacity. So
yes. Now, my lord, the shocking, my lord,
continue on the next episode. Chaudhary will have to leave.
my lord,
I miss a flight actually.
yes, very good. My lord, will it be after reopening, my lord?
Whenever you say, I can keep it on the last day if you just want to conclude in. If you are there. Mr. Shah will not be there. So that's safe enough. So you be there and conclude.
Very well. No, actually, I was. No, my lord.
No, you can come back after the vacation. No difficulty.
So
Then
then
we
we'll
won't
have-
have the vacation. Now we have timelines,
So
and now
what if-
registrars will remind us when we are late in passing our judgments, as per the latest Supreme Court directives.
I didn't know.
Yes, actually.
Well,
That is the
whatever
directive.
is,
The
if you
registrars
have-
will remind us.
But that will
Okay,
depend on the conclusion of arguments.
but my lord,
The timeline won't.
That is
start.
also being done by some of us.
my lord, whatever is more convenient to your
So
lord.
then, if you don't conclude now, you will have to conclude before the winter vacation.
Yes, yes, no, one day.
Before the winter vacation. Just before the winter.
No, no, my lord, what if it's convenient, I'll come and do it on Friday.
Let us keep
Other-
it on Friday. Let us see if you
No, my lord, if your lordship, my lord,
at least send your written notes of arguments on that date, because I'll not remember whatever you say.
no, my lord, I'll tell your
Every
lordship.
detail
I
I'll
was-
not remember unless
I
you
was-
send your written notes. Definitely I'll recollect if I see your written notes.
Yes, I was supposed to be in Odisha on the last day,
So
but then I will, my lord,
let
stay
us
back
conclude
and do
arguments
it.
right now. What else you'll say?
No, then, my lord, Friday. I'll come. I'll come and do it and
Odisha,
finish
do
it.
it online. You can do. Can you?
Yes, yes, I'll
will you
manage
be in a
it.
position to do it
Milord,
online?
this is more important. I'll manage it. I'll
No,
finish it.
You can do it online. Why not?
No. I'll come and do this on next Friday.
Well, if just in case, my lord, your lordship had some queries for me, then, my lord, I will not be able to respond on Friday.
No,
I will
Milord,
not, my
I'll
lord,
finish
make
it off.
I will not
There is-
make any new arguments, my lord, because, my lord, just in case, my lord, after hearing my learned from your lordship have one or two queries, my lord, I will be in some difficulty. I won't be able to answer your lordship.
Milord, whichever way, I'll come next Friday. I'll finish my part.
keep
I'll
it next
give my
Friday.
note.
Very well.
Hard in part for further hearing on September 26, 2025.
Great.